Hello. Thank you for joining this webinar on remediation orders under the Building Safety Act. By way of brief introduction, my name is Harry Smith and I'm a barrister at Keating Chambers. I've been instructed and am currently instructed in a number of cases involving remediation orders and indeed the whole gamut of other remedies under the Building Safety Act, remediation contribution orders, building liability orders and the product liability provisions. What I propose to do in this talk is start with a recap of what the legislation says about remediation orders, and then work through the case law and some of the topics that have emerged from that over the last couple of years. So as most of you will know, a remediation order is an order which requires a landlord to put right dangerous defects in a residential building. And I've put the key provisions of the legislation on the slide. So under section 123, subsection 2, a remediation order is an order made by the first tier tribunal on the application of an interested person, requiring a relevant landlord to do one or both of the following by a specified time. A, remedy specified relevant defects in a specified relevant building. B, take specified relevant steps in relation to a specified relevant defect in a specified relevant building. Specified in that section obviously means specified in the order. Then the second provision is in the 2022 regulations, and it's the provision which empowers the tribunal to actually make a remediation order, because that power was absent from the Act. And that section says the regulation says the first tier tribunal may, on an application made by an interested person, make a remediation order under section 123 of the Act. Now, 3 points arise immediately from those provisions. The first is that the jurisdiction to make the order lies with the tribunal. So that's the forum in which applications for remediation orders must be made. You can't make an application for a remediation order to the High Court. The second point is that the availability of remediation orders is subject to meeting various gateway criteria. So you need to have an interested person who makes the application. There has to be a relevant landlord. There have to be relevant defects, and there has to be a relevant building. And I'll come on to what each of those means in a little more detail in a moment. And then the third point is this wording in the second part of the slide. The first tier tribunal may make a remediation order. So there's a discretion, and I'll come on to that in a bit more detail later on too. So starting with the definitions, an interested person is defined by subsection 5 of section 123. And there's a list of people who or entities that may be interested persons for the purposes of the section on the slide. The regulator in subsection A is the health and safety executive. And notice that D, a person with a legal or equitable interest in the relevant building or any part of it, can include the freeholder if the freeholder is a separate entity to the landlord, as sometimes happens. And there's a case called Purbeck House in which that was the situation, and in which the freeholder obtained a remediation order against the landlord. The next definition is relevant building, and that's dealt with in section 117.2. I haven't put the full definition on the slide because it's quite lengthy, but in summary, the building has to be a self-contained building or part of such a building that contains at least 2 dwellings and is at least 11 meters high or has at least 5 stories. So then the next gateway criterion is that of the relevant landlord. That's defined by subsection 3 of section 123. And it means in relation to a relevant defect in a relevant building, a landlord under a lease of the building or any part of it who is required under the lease or by virtue of an enactment to repair or maintain anything relating to the relevant defect. So in most cases, a remediation order will not impose new obligations on the landlord. It will simply force the landlord to comply with its existing repair and maintenance obligations. And that factor, I think, has loomed large in some of the cases where landlords have sought to argue that for one reason or another, it would be unfair to require them to remediate the defects. The difficulty with that argument is often that ultimately it was something they were always required to do. Now, in the Thanet Lodge case, which I've put on the slide, a landlord whose repair and maintenance obligations had been transferred to a management company under the 2002 Act was not a relevant landlord under that definition because it was no longer required to maintain or repair anything relating to the relevant defects. So that brings me on to the definition of relevant defect, which is in section 120, sub 2. And we see that it means a defect as regards the relevant building that arises as a result of anything done or not done, or anything used or not used in connection with relevant works, and which causes a building safety risk. That obviously raises the question, what are relevant works? And they're defined in the following subsection. In summary, as works relating to the construction or conversion of the building and or works carried out by the relevant landlord or management company within the relevant period. Pausing there, what's the relevant period? Well, we see that at the bottom of the slide. It's the period of 30 years ending with the time that the section came into force. Now, this section came into force on the 28th of June 2022. And that means that remediation orders are only available, subject to the next point in this paragraph on the slide, only available in respect of defects carried out in work carried out in the 30-year period before the 28th of June 2022. That's the relevant period, but the exception, which is on the slide after the capitalized word or, is where work is undertaken after that period in order to remedy a relevant defect. But otherwise, as I say, remediation orders are limited to work carried out in the 30-year period preceding 28th of June 2022. So that's an important limitation to be aware of. The second part of the definition of relevant defect, as we saw, was that the defect has to cause a building safety risk. And the definition of that is up on the slide, comes from section 120 sub 2. In fact, I think that's a typo. It should say section 120 sub 5. And as we see, the definition is a risk to the safety of people in or about the building arising from the spread of fire or the collapse of the building or any part of it. What degree of risk is required to meet that test, one might ask? Well, we have an answer to that question from the Vista Tower Tribunal decision, which I've put on the slide. And what they say there is that the better view is that any risk above low risk, meaning the ordinary unavoidable fire risks in residential buildings and or in relation to a PAS assessment, that fire spread would be within normal expectations, maybe a building safety risk. So anything above low risk is likely to qualify as a relevant defect. So those are the gateway criteria. And that brings me on to the question of the tribunal's discretion. And I pointed out a moment ago that the regulations say may, not must. And that wording suggests that there is a discretion and also raises a question as to the test that will be applied in exercising it. The legislation doesn't give us any direct help in answering that question. We might compare sections 124 and section 130, which I've put on the slide. They deal with remediation contribution orders and BLOs respectively. And they both say that the order may be made if the tribunal or the court, as the case may be, considers it just and equitable to do so. That wording is omitted from section 123 and from the regulations which implement it. Why? Well, I don't think Parliament is inviting the tribunal to make unjust and inequitable remediation orders. I think the better view is probably that Parliament intended the tribunal's focus to be on whether making an order would serve the overarching legislative purpose of remediating dangerous defects in tall buildings, rather than necessarily achieving strict fairness between the parties who happen to be before it. And as we'll see, by and large, that is the approach that the tribunal has taken when applying Section 123. In contrast, RCOs and BLOs are directed to ensuring that the burden of rectifying dangerous defects is borne by those responsible for them. Those remedies are much more directed to doing justice between the parties before the court or tribunal, and so one can see why the just and equitable wording is present in those provisions. Now, before we look at the cases on discretion, it is worth saying, I think, that there are now 17 published tribunal decisions on remediation orders. In one of those cases, only one, and it's the Thanet Lodge case that we looked at a moment ago, the application failed because, as we saw, the respondent wasn't a relevant landlord, and so the gateway criteria weren't met. But in all of the other cases where the gateway criteria were met, a remediation order was made. And that track record certainly raises a question as to whether a remediation order is inevitable or practically inevitable where the gateway criteria are met. Nonetheless, as we will see, the tribunal has in fact gone to some pains to emphasize that it does have a discretion, both as to whether to make an order and as to the terms of any order that is made. And it's also worth saying that tribunal decisions do not create, first-tier tribunal decisions do not create binding precedent. Though in practice the tribunal does have regard to its own jurisprudence. So the cases we are going to be looking at should be regarded as indications of the approach that the FTT might or is likely to take, rather than as anything more concrete than that. So in the earliest cases in 2023, there was no real analysis of whether the tribunal had a discretion to refuse a remediation order. It appears to have been assumed by the tribunal at that stage that once the gateway criteria were met, an order would be made. And then in the Vista Tower and Chocolate Box cases, which are on the slide, that was taken one step further, and it was actually argued by the applicants that once the gateway criteria were met, the tribunal was obliged to make a remediation order. In other words, it was argued that there was no discretion, despite the word may, to refuse an order where the gateway criteria were met. And in both of those cases, that no discretion submission was, I think, unsurprisingly rejected. And that point can, I think, now be regarded as more or less settled, notwithstanding the absence of any strictly binding precedent. What has always been much less clear is the test which is to be applied by the tribunal in exercising its discretion. As we've seen, the legislation does not provide any express criteria, and different tribunal judges have proposed different formulations. So in the Space Apartments case on the slide, the tribunal applied a balance of prejudice test and concluded that not making a remediation order would cause greater prejudice to the applicants than making a remediation order would cause to the respondent. In the Chocolate Box case, the tribunal said rather differently that it stood to reason that notwithstanding the absence of the words just and equitable from section 123, it would not make an order unless it was both just and equitable or fair to do so. And I've put an extract from the tribunal's reasoning on the slide, and I'll just read out the part in bold. It may not be a simple task to identify the difference in outcome from applying a test of just and equitable, or arguably just and convenient, or perhaps balance of prejudice, or an exercise of discretion in a wide sense, not adopting such specific phrases. Perhaps a somewhat understandably non-committal analysis. But doubt has since been expressed on each of these formulations by subsequent tribunal decisions. Now, we don't have an appellate decision from the upper tribunal to tell us what the answer is. But the view that has now, I think, prevailed at tribunal level is that the tribunal's discretion should be exercised in favour of making a remediation order, where doing so will further the objective of the legislation, which is to secure the safety of people in or about buildings and to improve the standard of buildings. So that's the objective that the tribunal are going to have in mind, rather than, I think, necessarily a just and equitable test or quasi-test. And that's seen most clearly in the Empire Square decision from June this year. And we see at the first part of the extract that I put on the slide, the tribunal departed from, well, I shouldn't say departed because it wasn't binding, but disagreed with the reasoning in Chocolate Box. And then went on to say, the Act is solution-focused rather than blame-focused. It is concerned with the building, not with the parties to the application. We must take a proposive approach, ask ourselves what the best answer is in this application to achieve remediation of the relevant defects in the building for the safety of the leaseholders. The outcome of that assessment must be within a range of reasonable decisions, but would not be open to challenge unless no reasonable decision maker on the facts known to it could have come to the same decision. That is qualitatively different from an argument that a decision is not just and equitable because of some key feature or behaviour of a party. And so, as matters stand, the position appears to be that the tribunal will grant a remediation order if doing so will further the statutory objective of remediating relevant defects in tall buildings, irrespective of whether that outcome might arguably be unfair by reference to the characteristics, interests, or conduct of the parties to the application. But as I said a moment ago, in practice, the reality appears to be that if the gateway criteria are met, a remediation order is likely to be made. Certainly, we are yet to see a case which bucks that trend. Now, that has held true even where the landlord indicated that it was willing to carry out the remedial work. And I've put two cases, the Space Apartments case and 8 Artillery Row, on the slide where that was the case. And it also held true in Empire Square, which was on the preceding slide, where the landlord was actually carrying out remedial work at the time. Though in that case, the tribunal suspended the order on terms that the landlord was required to update the leaseholders on progress at least once in every 3 months. And the seeming inevitability of a remediation order being made has held true also where the leaseholders had defect insurance covering the cost of remedial work. Which was the position in the central case on the second half of the slide, in which I acted for the leaseholders. Now, the landlord in that case argued that a remediation order would effectively transfer the insurer's obligation to carry out or pay for remedial work for which it had been paid a premium to the landlord, and that this was an abuse of the legislation and could not have reflected Parliament's intention. The difficulty with that argument was that as a result of Schedule 8 to the Building Safety Act, the leaseholders were no longer liable to pay for the remedial costs of rectifying the relevant defects via the service charge, which in turn meant that there was, well, at least arguably, and this was the submission I made to the tribunal, at least arguably no loss for the insurer to indemnify under the policy. Now, in the result, the leaseholders, my clients, were successful and the tribunal granted the remediation order. And the tribunal took the view that even if the insurer had been liable under the policy, that would not be determinative, and that ultimately its focus was on ensuring practically that the defects in the building were rectified. And that approach was, I think, entirely consistent with the other authorities to which I've just referred. But the tribunal did accept that the existence of a insurance policy might be relevant to the exercise of its discretion, albeit without a great deal of enthusiasm. And I've put the extract on the slide. So it's the second half of that quotation. Given the wide and unfettered by statute discretion of the tribunal, we accept that issues such as the existence of the insurance policy might be something that can be taken into account as part of the tribunal exercising its discretion, but we put it no higher than that. So the point survives to fight another day, and who knows what the outcome might be on slightly different facts. So much for discretion. I want to move on now to look at how the tribunal will frame a remediation order and the powers that it has in that regard. Now, there are no hard and fast rules here. In some cases, the tribunal has been very prescriptive as to the work which the landlord is required to do. So, for example, in the Vista Tower case, a full specification of remedial work was specified in the schedule to the order. But in other cases, the order has been framed in very general terms, and I've put an example of that, the Spur House decision, or the order from the Spur House case, on the slide. I won't read it out, but as you can say, it's very, very short and gives the landlord a fair bit of latitude in how it goes about dealing with the relevant defects. Now, the order will, this one doesn't actually, but the order will typically give the parties permission to apply to the tribunal in the event that adjustments are needed to the scope or the timing of the work. So if an order is made in very broad terms, like this one, and the applicant is dissatisfied with the remedial work that the landlord proposes to carry out or is carrying out, the applicant may apply to the tribunal to make the order more prescriptive. Now, in the Space Apartments case, the tribunal found that it had the power to make ancillary orders where these were necessary to make a remediation order effective and workable, and those orders have taken various forms. So, for example, in the Space Apartments case itself, the tribunal ordered that reports be produced at the conclusion of the remedial works to verify that the fire risks had been sufficiently addressed. Similarly, in the Chocolate Box and Purbeck House cases, the landlord was ordered to produce a through to PAS 9980/2022 to show that the risk had been reduced to an acceptable level. In the Vista Tower and 8 Artillery Row cases, the landlord was required to obtain a form EWS1 on completion of the remedial work. And in Empire Square, as I've already mentioned, reporting requirements were imposed as a condition of the suspension of the remediation order. So finally, just a word about legal costs. Rule 13 of the tribunal rules provides, and you can see this on the slide, that orders for costs will be made only if a person has acted unreasonably in bringing, defending, or conducting proceedings. And the fact that a party has lost is not on its own enough to meet the threshold of unreasonableness. So the result is that in general, parties in the FTT bear their own costs. However, recently in the Empire Square case, the tribunal concluded that it had the power to order the payment of legal costs as part of a remediation contribution order. Now, that decision was based on the specific wording of Section 124, which empowers the tribunal, and again, I've put this on the slide, to make an order for payments to meet costs incurred or to be incurred in remedying or otherwise in connection with relevant defects relating to the relevant building. So costs incurred or to be incurred in connection with relevant defects. And the tribunal concluded the costs of legal proceedings, which were directed to ensuring that the relevant building was remediated, fell within this wording. Now, this does, I think, open up the possibility of applying to the tribunal for both a remediation order to require the landlord to remediate the building and a remediation contribution order to recover the legal costs expended in bringing the application. So if that's right and that works, then that appears to open up a new sphere of cost recovery in relation to these remedies that was previously thought to be unavailable. And we may, I suppose, start to see parties who have previously obtained remediation orders and not recovered their costs making applications now to recover their costs in relation to the remediation order via a remediation contribution order application. But this does come with the health warning that I mentioned earlier, which is that tribunal decisions do not create binding precedent unless and until the costs point in Empire Square is considered by the upper tribunal. We don't necessarily know what another tribunal would do if seized with the question. But as matters stand, it does appear to be worth a try. So that's all from me. If you are interested in further reading on this or on any other Building Safety Act topic, can I just take this opportunity to recommend Keating Chambers' BSA update, of which there are now 2 editions. You can find it on Chambers' website, and it is genuinely really good. There are articles on all sorts of difficult topics, ranging from contribution claims in the context of RCOs to limitation in the context of BLOs. And there is a really helpful Building Safety Act A to Z at the end, updated with key developments in each edition, which is a very easy and digestible way of keeping up to date. So I highly recommend that. But otherwise, all that remains is for me to say thank you for listening and best of luck with your BSA related adventures in the future.